A single, paid advertisement with just a few factual errors almost cost the New York Times $500,000 and could have fundamentally crippled American journalism as we know it today. In 1960, during the height of the civil rights movement, the New York Times ran an ad criticizing the Montgomery, Alabama Police Department, co-signed by prominent civil rights leaders. While most claims were accurate, some minor inaccuracies led to a libel suit that reached the U.S. Supreme Court. The question at its core: could a newspaper be sued into oblivion over an honest mistake in an ad? We'll walk through the arguments, the landmark decision of March 9, 1964, and by the end, you'll understand the actual malice standard, and why this seemingly small case is the reason major news organizations can still report aggressively without constant fear of bankruptcy from legal challenges. In 1960, a seemingly innocuous full-page advertisement in the New York Times, seeking donations for the civil rights movement, inadvertently triggered a legal battle that would fundamentally reshape the landscape of American journalism. This ad contained a handful of factual errors regarding the actions of the Montgomery, Alabama Police Department. What followed was a lawsuit for defamation by an unlikely plaintiff. L.B. Sullivan, Montgomery's public safety commissioner, who claimed the ad's criticisms of the police were directed at him personally. On March 9, 1964, the U.S. Supreme Court in New York Times Co. v. Sullivan, case number 376 U.S. 254, rendered a unanimous decision that redefined what a public official must prove to win a libel suit, thus extending unprecedented protection to the press. This ruling is not just legal history. It remains the bedrock of journalistic freedom, particularly when reporting on public figures and government actions. The advertisement itself, titled "Heed Their Rising Voices," cost civil rights activists an estimated $4,800 to place in the March 29, 1960 edition of the New York Times, but its true cost would prove astronomical. This full-page appeal, signed by 60 prominent Americans, sought donations for Dr. Martin Luther King Jr.'s legal defense against what many saw as politically motivated perjury charges in Alabama. The ad painted a stark picture of the civil rights movement struggles, criticizing the Montgomery, Alabama Police Department's response to peaceful protests, describing it as an unprecedented wave of terror. For instance, it claimed that truckloads of armed police ringed the Alabama State College campus, a detail that, while evocative, was not entirely accurate according to subsequent court findings. Crucially, amidst these largely accurate condemnations, several factual inaccuracies about specific police actions were later identified, including a false claim about the college's dining hall being padlocked. It was these comparatively minor factual discrepancies, rather than the ad's broader, accurate criticisms, that would become the foundation of a sweeping legal challenge. But who, exactly, was targeted by this criticism? The truly astonishing detail is that the specific individual who sued the Times for defamation wasn't even named in the advertisement. L.B. Sullivan, Montgomery, Alabama's public safety commissioner, despite never being explicitly identified in "Heed Their Rising Voices," which focused on the actions of the Southern violators, and the police, interpreted the criticisms leveled against the Montgomery Police Department as direct attacks on his character and professional integrity. Under an Alabama statute requiring public figures to demand a retraction before seeking punitive damages in libel lawsuits, Commissioner Sullivan, represented by attorney M. Roland Nachman, Jr., formally requested the Times retract the ad, specifically citing several alleged factual inaccuracies. When no retraction was issued by the newspaper, which stood by the ad's general message, Sullivan proceeded to file a libel suit, claiming that the advertisement's factual inaccuracies, like the number of times Dr. Martin Luther King, Jr. had been arrested 4, not 7, or that students were locked out of their dining hall, had severely damaged his reputation. In a stunning initial verdict, an Alabama state court awarded Commissioner Sullivan a staggering $500,000 in damages, an almost unimaginable sum in 1960, equivalent to over $5 million today. The question then became, how did a state court judgment against the New York Times escalate all the way to the United States Supreme Court? A staggering $500,000 judgment threatened to silence a national newspaper. The New York Times, facing an Alabama state court's decision upholding Sullivan's libel claim, quickly recognized the profound implications this ruling had far beyond a local dispute. The Times challenged the Alabama court's decision, arguing that such a precedent would severely restrict their ability, and the ability of all news organizations, to report on public officials without fear of financially ruinous lawsuits. The case escalated rapidly through the appellate courts, reaching the U.S. Supreme Court under case number 376 U.S. 254. The core legal question before the justices revolved around the inherent conflict between a public official's right to protect their reputation and the press's freedom of speech, a right enshrined in the First Amendment. This was not a simple libel dispute. It was a constitutional clash. Had the Alabama verdict stood, news organizations covering the civil rights movement from afar, like the Times, would have faced crippling libel judgments for minor factual errors, effectively chilling vital reporting on critical national issues. The Supreme Court's involvement signaled a clear recognition that this case touched upon the very foundation of American democracy and an informed public. What would this recognition mean for the future of investigative journalism? How could a newspaper, facing a $500,000 judgment, not just survive, but fundamentally reshape American jurisprudence? On March 9, 1964, the U.S. Supreme Court issued its landmark unanimous decision in New York Times Co. v. Sullivan, found at 376 U.S. 254. This ruling didn't just overturn the Alabama lower court's decision. It fundamentally expanded protections for expression and redefined the meaning of a free press in the United States. The court established the actual malice standard for libel suits involving public officials. This meant that for Commissioner Sullivan or any other public official to win a defamation claim, they would have to prove the publisher acted with reckless disregard for the truth or with knowing falsity. The justices recognized that erroneous statement is inevitable in free debate, and this decision made it significantly harder for public officials to silence criticism through libel litigation. This was a vital safeguard, celebrated as a triumph for robust, uninhibited public debate on matters of public concern and political discourse. But after 60 years, can this revolutionary shield for the press endure? Yet, despite its 6 decades of entrenchment, a profound question now looms. Can the Sullivan Standard truly survive intact until 2026? For 60 years, New York Times Co. v. Sullivan has been celebrated as the bedrock of American press freedom, a crucial shield allowing journalists to critically examine public officials without constant fear of ruinous lawsuits. The ruling created a higher bar for libel against public officials, acknowledging their inherent access to counter false statements and the public's vital need to scrutinize power. However, as hinted by the title, this landmark decision is now explicitly considered a target for re-evaluation. Prominent legal figures, including Supreme Court Justices Clarence Thomas and Neil Gorsuch, have openly expressed a desire to revisit and potentially weaken the actual malice standard, arguing it provides too much protection to the press. For instance, in a 2019 dissent, Justice Thomas called Sullivan a policy-driven decision masquerading as a constitutional command. The outcome of any such challenge could fundamentally alter the relationship between the press, public officials, and the truth, potentially making it much easier for public figures to silence critical reporting by suing for defamation, thereby undermining the very protections the court established in 1964. This video presents publicly documented information. It is for educational purposes, not legal advice. The New York Times Co. v. Sullivan decision, reached unanimously on March 9, 1964, fundamentally altered the landscape of free expression, establishing a critical barrier against libel claims that could otherwise stifle public discourse. It created the actual malice standard, requiring public officials to prove a false statement was made with knowledge of its falsity or with reckless disregard for the truth. Yet, as we approach 2026, the ongoing debate about revisiting or even overturning this precedent highlights its enduring, and perhaps increasingly fragile, significance for press freedom, and by extension, the public's access to robust information. Considering the potential for changes to the Sullivan standard, how might future libel cases involving public figures differ if this protection were weakened or removed? Share your thoughts in the comments below. To continue understanding the intricate balance between legal precedent and evolving societal values, make sure you subscribe. And if you're interested in how other landmark cases have shaped our constitutional rights, watch my breakdown of Miranda v. Arizona next.